Well, good morning, everyone, and welcome to Back to Business, a special series of webinars put on by the Mountain View Chamber of Commerce to assist our local businesses in their recovery from the pandemic. Today's session, put on in partnership with the City of Mountain View, will address compliance with the Americans with Disabilities Act, or ADA. As many of you know, the ADA is a national law that was put into effect to ensure that equal access be reasonably provided to all patrons, regardless of mobility or other issues. Our merchants certainly embrace this effort, wishing to welcome everyone into their storefronts. However, during the pandemic, quick changes were made to many facilities, such as expanding outdoors, just so the businesses could survive. This has added conditions that may have left them vulnerable to violations. And in fact, over the past few weeks, a number of our businesses have been served lawsuits citing ADA mobility access violations. We recognize the hardships facing our struggling businesses at this time, as well as the legal right of access for disabled persons. In this important webinar, our presenters will help shed light on what it means to be compliant in this current situation, as well as your legal rights and courses of action. Joining us today are Roger Miller, a certified access specialist, or CASP, I hope I'm saying that right, to talk about accessibility and the role of CASPs, common issues and areas of concern. We have David Bassinger from the city staff, community development and building, on what role the city plays related to accessibility, including permitting. Attorneys Ken Van Vleck and Martin Orlick will be speaking on the nature of ADA lawsuits, what you do to avoid being served, and what you can do if you have been served. If you have questions, and I know there will be them, please place them into the Q&A box, and we'll try to get as many of them as we can. Please remember, though, we cannot deal with the specifics of an individual case. We need to keep the conversation more broad. We'll provide contact information at the end for any follow-up. Finally, we are grateful to Facebook for helping to sponsor today's session. So, with all of that, we have a full 90 minutes, a packed 90 minutes to get into. So let me please welcome Roger Miller.
Hi, everybody. Let me get my screen share going. Can you see the presentation?
Yes, we can, Roger.
Okay. So what I'm going to talk about is accessibility in the built environment, and that is physical construction. Imagine you turn your building upside down and shake anything that falls out except your dining tables is not included. So that's what we're going to focus on. So I'm a certified access specialist and a construction manager. I want to emphasize I'm not an architect or an attorney, so I can't do design drawings for you, and I can't give you legal advice. You've got attorneys that are going to be online doing that as we go forward. The underlying issue with the built environment today is it's not accessible. Imagine yourself paralyzed for a day, and there's some videos that are available of somebody walking through the world in a wheelchair and what it takes to do that. I'm not going to play those right now. If we were in person, I would have been playing them at the introduction. But basically, you're put yourself in the shoes of somebody that is suffering from a disability and how they're going to function in the environment. Just nomenclature, we used to call it handicapped and now we call it disabled. It's politically correct, and I'm showing the guy in the wheelchair doing pretty crazy stuff. It's amazing what some people can do. The concept that you want to keep in mind is equal. I want to give everybody an equal opportunity to enjoy the use of your facility, no matter what their disability. And remember, not every disability is in a wheelchair. You've got people with walkers, people with visual impairments, people with hearing impairments. All those functions have to be considered when you're looking at the built environment. In 1990s, when the Americans with Disabilities Act was signed into force by George Bush, the first George Bush, and it was an effort to start the process of giving people that are disabled equal access to the world. There's a shameful history of the way we treated disabled at the beginning of the century, and this was an attempt to start turning that around. Remember that the Americans with Disabilities Act is a civil rights act. It's discrimination, and the basis of lawsuit is we discriminate against individuals because of a disability. Also, accessibility and compliance is a good business. I don't know if you've ever experienced this, but somebody shows up to a restaurant in a wheelchair and they can't get in the restaurant with 4 or 5 friends, and they can turn their back on that restaurant and go to someplace else. 1 in 5 Americans have some kind of disability. 1 in 10 have a severe disability. The buying the buying capability of people with disabilities is huge. There's over 50 million people with disabilities in the United States, and that's expected to double by 1930, or 2030, not 1930, obviously. $3 trillion is the buying power. 157 million Americans will be living with chronic illnesses. This is all statistics from the census. Remember, more about it, it's good business. People over 65, 71.5 million baby boomers by 2030. You've got a huge population that you want to be accommodating to. And it's good for everybody. It's the law. And whether we like it or not, it's the law that we need to comply with. Helps disabled people become a member of society, affords disabled individuals the opportunity to function in society. We're most likely all going to experience some sort of disability in our life. You break a leg and you're walking with crutches, that's how you might experience it. And as we get older, we're all less able to motivate around. We age and our bodies don't last forever. So how do you avoid a lawsuit? Well, the easiest way is to make your property fully accessible. And the way you can do that is do an accessibility assessment to determine what's not compliant, and then come up with a plan to address that. If you're going to buy a new property or release a new property, do a pre-purchase investigation and determine who's going to be responsible for making the necessary improvements. Also implement policies and procedures that accommodate people with special needs. This is a sensitive area. You don't want to be oversensitive to somebody with a disability, and it's not legal to ask somebody what their disability is. If they ask for an accommodation, you need to do what you can to make the accommodation. I'm involved in a lawsuit right now where somebody asked for accommodation and was refused, and that became the basis for the lawsuit. Some common misconceptions about accessibility lawsuits. The American Disabilities Act is a building code, it's not a law. ADA lawsuits are frivolous. They are not normally. ADA plaintiffs are vexatious and litigants. There are those, but not all of them are. Pre-litigation notice is not necessary. People seem to think they should be given previous notice. You've been notified by the law that was passed in 1990. Only landlords, not tenants, are liable. That's not true. Typically, the lease stipulates where the boundaries exist. Older buildings are exempt, grandfathered. That's definitely not the case. Any building built before 1992 needs to have an implementation plan to be making it accessible over time. Once you've had the idea that once you've had a lawsuit, you can't be sued again is a misconception. Using a licensed contractor and obtaining the proper building permits guarantees accessibility, and it does not. The building official is responsible for making sure that you're substantially in compliance with the code, but he doesn't check all the details. And that can be problematic if you have not complied 100%. Only people sitting in wheelchairs are considered disabled, and that's definitely not true. Classic story is a guy in a Harley Davidson pulls up and has a disabled sticker on his license plate, and the question is, why are you able to ride a motorcycle if you're disabled? Well, he has a heart condition and can only walk 50 feet. So not all disabilities are obvious. There's a misconception that nothing has been done in California to decrease unwarranted disability litigation. There are a number of actions in place, but what becomes the roadblock for a lot of the road actions is the disabled community says we've had since 1990 to start implementing these changes, and people haven't done it. That's a sound reason to continue to allow the lawsuits, which are the only things that sometimes triggers making things accessible. So there's some resources that you can take advantage of. The California Commissions on Disabilities, Disability Access, provides resources for public agencies, businesses, building officials, and CASPs. You can go there and you can see this list of the top 10 alleged construction-related ADA violations. This is something that was implemented several years ago as part of an effort to try and reduce the lawsuits. They have some checklists on there that you can use during course of construction. So one of the things that was mentioned earlier is the temporary parklets, and people have put those into parking spaces, and I've been involved in one lawsuit where they put the parklet over the accessible parking, and then they got sued because they did that. These new parklets must be accessible. Even though they're temporary, they still need to be accessible to somebody in a wheelchair, somebody that's visually impaired. You have to have the clearance around tables. You have to maintain your accessible parking. 5% of the tables need to be accessible. You need to have an accessible route. And one that a lot of people overlook is you have to have 80 inches of overhead clearance. You put the awnings over it. And if they're less than 80 inches for somebody that's visually impaired, that could be a hazard that would cause them to bump their head. Continuing on the theme of the Senate bills that have been involved in trying to make this clearer for everybody. There's a whole history of Senate bills that have been proposed and passed for the ADA and California Building Code. And they continue each year to have several things on the docket to try and make this more straightforward with people. So the question everybody has is, how do I make my facility accessible? First of all, hire a professional. If you think it's expensive to hire a professional, wait until you hire an amateur. This is not a time for DIY. I get a lot of clients that I give them an accessibility assessment, and then they call me and they want to do an accessible bathroom on their own without getting an architect involved or without getting a design professional involved. It's a big mistake. There's a lot of complex code information that you need to digest, and it's really hard if you're not an expert at the code to get it right. So first step is to have your facility inspected. That's either hire a certified access specialist or somebody that has experience with accessibility. An architect oftentimes can do that as well, and have them give you a report. There's a standard report that we do called a construction-related accessibility standards compliance report, which has a standard format that's stipulated by one of the Senate bills that was passed in 2008 that created the CASP program, and it gives you a fairly detailed list of what needs to be addressed and the codes. Typically, when we do these reports, we do them to the current code, and then if there's something that's problematic to fix, we look and see if it was built to properly correct code at the time. Once you get the report, then develop an implementation plan and follow the implementation plan. If your property was built before 1992 and has not had significant requirement improvements, you're still required to have a program for architectural barrier removal where it's readily achievable. What that means is it's not too difficult to do and not too expensive. Expensive is a relative term, and you're going to have to prove to a judge that it was not too expensive. I don't think you want to go through that process, but it is possible. There are some funds available, tax incentives and tax deduction for some businesses for accessibility improvements and accessibility reports. There's also help available through the California Capital Access Program where you can get loans. So what is a CASP? I'm a certified access specialist. Senate Bill 1608 was passed in 2008, and it's administered by the Department of State Architect. You can go to the website, and there's more now, but as of 12/31/18, there were 780 accessible tech certified access specialists. There's about 1,000 now, I believe, in total. The main objective of the Senate bill was to reduce the number of serial lawsuits by providing voluntary compliance and prevention, encourage business owners to make their businesses more successful, and require design professionals and the building department personnel to maintain minimum number of hours of continuing education. One of the things to be aware of is that when the code changes, it doesn't require that you make changes to your facility unless you do an improvement. But when you have a professional that's doing it, the code does change from time to time, and they need to be conscious of what the most recent code is and what's changed, so that when you do a new modification or improvement, it's compliant with the current code. So how do you ensure compliance? Hire a CASP. You can request that a CASP post a sticker in the window, although that oftentimes is a target for litigants to come and see where there's something was missed. It's trying to help resolve lawsuits. There's a 90-day stay for a lawsuit, an early evaluation conference if you've completed an accessibility assessment ahead of time. But you have to have the assessment done before you get sued. There's an effort to reduce unwarranted lawsuits. They've put some restrictions on attorneys that file lawsuits. The way damages are calculated has been changed and reduced to be more reasonable than it was initially. So there's a Senate Bill 269, which is known as the 120-day grace period, and I get a lot of questions about this. There's very limited benefit to this Senate bill. You're not liable for the minimum statutory damages for a period of 120 days from the date that the corrections were completed or the report was done. But you have to have 50 or fewer employees, you have to be in business for 3 years, and you must have the inspection prior to a claim. And you have to complete all the corrections within 120 days. If you get presented with a lawsuit, you have to give the inspection report on all findings to the plaintiff. You must file a report with DSA and post notices on site. And you must have a CASP come back and inspect within 30 days of the building department final approval. Typically for these improvements, you're going to have to pull a permit as well. So I haven't found many cases where this grace period does people a lot of benefit, but it is available if you've got small stuff that you can do quickly and you got the money to do it. The basis for the law is the UNRU Act. That's where we get sued because we're discriminated against a person, as I said earlier in the presentation. The ADA is a Civil Rights Act, and it's suing the reason you get sued is because you're discriminated against somebody that was disabled by having a physical barrier to their ability to use your property. Some comparisons between the ADA and the CBC. The California Building Code goes back to 1968. The Americans with Disabilities Act was started in 1991. It's required for actually last 31 years. Alterations to buildings after 1992 required for the last 20 years, new construction for the first occupancy. So basically what has to happen if you've got a building that's an existing building, it has to either comply with the code at the time it was built or in 1992 if it was built before 1992. And if it gets modified or if it's a newer building, it has to comply with the code at the time it was built. So I won't spend much time on what we can do. In EPM, the company I represent, we're an accessibility consulting company, and we can help you with your surveys. We can help you with litigation consulting. We can help you assess your property. And one of the things we can do is help review drawings when you're getting ready to do an improvement and make sure that the drawings are correct and that you don't have something hidden in the drawings that's going to leave you with a non-compliant alteration. So what's involved in the survey? Basically, the pre-survey is to define the scope of what we're going to inspect. Typically, if you're in the strip mall and you're a store, we'd inspect the door, your entry door in. If you're on the strip mall and we're inspecting the common areas, it would be the common areas up to the entry door. We do a physical measurements on site. We come and measure the doors, the bathrooms, the counters, all of the different elements that are required to be accessible. We'll give you a draft report that contains a list of everything that's not compliant with key code references that you can pass on to your design professional. We can review the report with you either on site or by phone. And then once we've incorporated your comments, we'll give you a final report with a hard copy. If you decide to do an implementation plan, we can either help you develop one or review yours. So the deliverable is a final report and a CASP pending certification unless we find everything accessible. And I'll tell you, there's very few properties where I find everything accessible. There's usually something that's not quite right. That's everything. Anybody there?
You're on mute, Peter.
Hey, Peter, you're on mute.
There we go.
Right.
All right.
Not hearing
Roger,
any noise in the background. I wonder if I'm still online.
I'm sorry?
I'm okay.
Okay. Roger, thank you very much for the presentation. There was a lot of great data presented there. I think that it was really fascinating to hear, all the different things that you look for and all the different things that are uncovered and the rationale behind a lot of them. I do want to hold off on some of the questions until the end of the presentation, but I think there were one or two that I think are relevant just to you, Roger. And if you don't mind just answering one or two of those.
Be glad.
Okay. So one of the questions that comes up is that if you have a parklet or a patio, as long as you offer outdoor seating, do you have to ensure that the parklet is compliant, or is it enough that the outdoor seating on the patio is compliant?
What the code says is that the seating needs to be dispersed to all of the different areas. So if you've got a parklet that is different experience than the interior, you need to have 5% of the seating in each location accessible. That may exceed 5% overall.
Another question that came up is this relative to customers only, or does it include access for employee only areas of the business?
So when you're building a new building, there's certain requirements for employee work areas. When you have an existing building, employee work areas are covered under Title I of the ADA that says that you have to adapt to an employee's disability. So if you have an employee that loses function of the hand or breaks a leg, then you have to adapt to their disability. But the CASP program, the CRESCA program, and the UNRAC do not address, and ADA do not address existing employee work areas.
Thank you for that.
The kitchen wouldn't be required to be accessible. The warehouse wouldn't require to be accessible.
Great. And then there was one other clarification question. Someone had heard that 5% of the tables and 5% of the seating had to be ADA compliant. Is that the correct number, or is there a different way of calculating?
That's correct, 5%.
Okay.
And it has to be dispersed. So again, if you've got a parklet and you've got interior, you've got to have 5% of each location, which may turn out to be more than 5% of your total seating.
Okay. We have other questions that have been asked, but I'm going to hold on to those because I believe that they're going to be addressed by some of our other speakers. But I want to thank you very much, Roger, for the information so far. I'd like to now, thank you. I'd like to now turn the mic over to David.
Okay. I'm with the City of Mountain View Building Department. We actually issue the permits that come in for construction. I think in terms of the accessibility requirements, we try and catch all those in the plan review statements that we do. It's been a little different with some of these outdoor seating dining areas that have been allowed through kind of the COVID. I think in general, there's been a big push to help the businesses stay solvent through all the hard times and allow some of these outdoor spaces. And then there's a little bit of a wrinkle in terms of the parklets are typically within the public right of way. So as far as the building department's permitting process, we typically work within the building envelope. Sometimes some of the outdoor seating that's fenced and enclosed, because the building code concerns beyond accessibility are basically primarily egress, life safety, getting people out of the buildings. So these parklets typically out of the public right of way have also gone through Public Works Department for some of their review and approval documents. We've given guidelines to the Public Works Department, as we always do, in terms of minimum accessibility, but also in terms of what Roger was commenting on. I mean, we typically review to the California Building Code, which is a slightly different version than the ADA sort of CASP level of review. It's just a different product of the same, but it doesn't always meet the same readily achievable requirements that you get with the ADA language. That's probably been our role through all this. We certainly are still available for all these accessibility questions. If you come down to the city or call or email us, we will respond and give you some assistance with this. The building inspectors at the city continually, particularly down on Castro Street, where we have a lot of these parklets, will go out and do some walkthroughs and help show the owners in terms of items of concern or non-compliance. We don't really do the design work or get the professionals involved to how to put the plans together to correct those items, but we can certainly walk through. So we are available for that.
Thank you, David. David, one question that I think is on people's mind is, when should they call the city and when should they call a CASP, such as Roger? If you could maybe describe the difference between the kinds of inspections that you both do.
Sure, and maybe Roger, if he wants to join in here. I mean, I think in terms of the building department, we're available for conversations, consultations all the time. But I think in terms of the items we're reviewing to is the California Building Codes Chapter 11B. And so that is the commercial accessibility requirements for buildings or within the buildings in terms of path of travel and things along those lines. The CASP level is a higher degree of review. Typically, it talks about more the ADA language, which really gets back to readily achievable. At that point, the CASP sort of review and assessment is helpful, as Roger said, because if you do that prior to a lawsuit, it does give you a little protection in terms of the lawsuits that are coming through. There's at least a document citing what violations there were through the ADA language. And if you have a path of compliance or what you're going to do to bring that into compliance, it certainly helps out a little bit more. The problem has been, and I think this is why the CASP program has been installed, the Chapter 11B is the adopted building code of state, but it does not, basically anyone can bring a lawsuit against someone for just about anything out of that code. There really isn't any sort of limiting factors, where if you're applying to the CASP or ADA language, it does require Department of Justice sort of inquiry into the lawsuit, which is a little higher degree. Roger, do you have anything to add?
Yeah, I had something. One of the things that we offer is the comprehensive review of an existing property, which can be helpful. I think typically the building department gets triggered when you're going to pull a permit for the area that you're going to do the permit in. And that necessarily needs to be compliant with the existing code. But when you're in a situation where you want to know if your existing property is correct, that's what our report looks at. And one of the things that we look at also is some of the stuff that's not the built environment. I'm involved in a lawsuit right now with a hotel where Part of the issue is some of the loose stuff that's set in place during operations. The coffee maker in the room was not outside the reach range in an accessible room. They put a little cabinet in the bathroom in a space which is supposed to be a clear floor space, that sort of thing. They've done some modifications to the property that were not done by building permit, and they didn't do them correctly. So we kind of are synergistic in that. The building department, and when you've got a new construction or a remodel, does an excellent job of reviewing the part that you're remodeling, but they're not looking at the whole property as a whole. The other thing we offer is the ability to get a list of everything, with a written list of everything, in a way that you can use it to hand to a design professional to start tackling those problems and prioritizing those problems. And we can help you figure out how to do that as stipulated by the Americans with Disabilities Act.
Great, thank you for that important clarification. I'd like to shift the focus a little bit now. One of the things that is very clear is that there are a number of our businesses that have either been issued warnings or are on the call today because they want to avoid getting served, but a number of them have already been served. And so we have two legal experts who are going to join us now, who will talk a bit more about kind of what you're up against and what the situation looks like and what kind of courses of action are open to you. So with that, let me kick it off to Ken. And Ken, one thing that I do want to say is that one of the questions that's come up, and if you could address this as part of your opening remarks here, is who's responsible for making a lot of these changes? Is it the restaurant owner, or is it the landlord? So if you could kind of talk a little bit again through kind of what they're experiencing and who's ultimately responsible. Thank you.
Well, thank you. That's actually a great question. It was where I was planning on starting anyway. So I do a lot of commercial real estate litigation. A part of my practice is in defending ADA lawsuits, but that also involves not just defending it, but deciding who is responsible for compliance. A typical client of mine might be a landlord that owns a building in which there are a number of commercial tenants. And in every one of those commercial leases, there is typically an assignment of the responsibility for compliance with the Americans with Disabilities Act. So a lease might say something to the effect of you, the commercial tenant, you've inspected the property, you've determined for your own purposes that it meets all of your needs. And we're informing you in advance that we have not done any type of a CASP inspection. We recommend you do that, but you and only you are responsible for compliance with the Americans with Disabilities Act and other laws. So then fast forward to the tenant may go and hire a CASP inspector. They might call Roger's office and say, come out and do our inspection. They want to, let's assume these people are running a restaurant. They're not architects. They're not lawyers. They don't understand the ADA the way lawyers and architects and Roger and others like them do. But they're going to do their best. So they hire a CASP inspector. They get their inspection. They make the required changes. They're fully in compliance with the ADA, and then they set up their restaurant. And now they're setting up their restaurant. They put their tables too close together. They move a giant potted plant over near the restroom because it looks nice there, but they don't realize that it inhibits opening the door as far as the door needs to be opened in order to allow somebody in. And they do a number of other sort of after the fact modifications. Today we might see the moving tables to the outside in order to have outside seating for COVID, and not realizing that you put a table on the sidewalk between the wheelchair accessibility ramp and the front door. So now you can't get past that table to get into the building. All of these would be potentially violations of the ADA. Who's responsible for that? Is it the landlord or is it the tenant? Well, I'll tell you that both the landlord and the tenant are likely to be sued for that. The landlord is ultimately responsible. The landlord will likely face an action by some complaining party. And that landlord is going to contact someone like me, and I'm going to contact the tenant and say, we expect that you will fully indemnify the landlord, and you will defend the landlord in this lawsuit because that's what you agreed to do in your lease. And by the way, you shouldn't have put the plant there, and you shouldn't have changed the locations of tables and other things, which all took you out of compliance with the ADA. A good start followed by a bad finish. So oftentimes that indemnity portion ends up being as costly as the rest of the lawsuit. We'll typically find that at this point, the defense of the lawsuit comes down to identifying the disability restrictions, the things, the physical barriers to entry, fixing those things, and then negotiating with the plaintiff's attorney about what's a reasonable amount of money to pay them to resolve the lawsuit. But yes, there is often a dispute between landlords and tenants, and this is something that, by the way, can be negotiated at the outset of the lease. You, as a tenant, you could say the landlord is going to be responsible for all ADA compliance issues, but most landlords are not going to agree to that because of the kinds of physical barriers I was just mentioning. They're entirely outside of the landlord's ability to control. Oftentimes, a typical commercial lease, the landlord is just giving you what's called a warm shell, which is I'm providing you with the basic utilities to the unit, and you're putting anything and everything inside of it. The landlord will take care of things out in the parking lot, such as ensuring that there's appropriate parking, but often these violations are within the restaurant or the other place of business itself. I did want to talk about a couple of the questions that I always get. The first is, how are we going to get rid of the Americans with Disabilities Act? It seems to be screwing up business for everybody. And the answer to that is, of course, we cannot, nor should we try, nor should we even entertain the thought of getting rid of the ADA. It serves a very reasonable function, and the businesses simply need to do, as Roger said, come into compliance with the ADA because it's good business. It makes sense to open your business to people of all types, regardless of their the limitations they may have. So then the next question is, what can we do to change the law to get rid of the frivolous lawsuits? And I hear all the time about, well, we have these what we call drive-by lawsuits. Somebody is saying they visited your restaurant or your computer store or your Harley Davidson sales floor a number of times before they finally filed a lawsuit against you. And in each of those occasions, they were met with some physical barrier, couldn't get in. And what can we do to get rid of what we're calling these frivolous lawsuits? And I think what should become very clear from this presentation is that those are not frivolous lawsuits, typically. Frivolous lawsuits means that no reasonable attorney would have entertained filing the lawsuit to begin with. And that, in my experience in defending ADA lawsuits, that is rarely the case. Most of the time, there are violations of the ADA, and those violations need to be addressed. And you can't simply say that, well, it's just unfair because they never gave me any warning. That's not the way the ADA operates. It is enforced by private citizens, and it is enforced primarily, we see in California anyway, by a very small group of highly specialized law firms that represent what I'm going to call a very small section of the disability community. But it is those people whose lawsuits trigger action. And frankly, we probably would not be having a panel like this to tell business owners how to comply with the ADA were it not for the fact that a number of people have been served with lawsuits, probably the majority of which come from those that very small section of the legal community that represents the disabled in these lawsuits. I don't think you can, nor do I think you should try to eliminate those lawsuits, and I don't believe that they're frivolous most of the time. I'm going to close out with one quick point, and then I'll turn this over to Martin he's also going to talk to you about how to defend these lawsuits. Oftentimes I compare this to what happens when you, as a business, you buy insurance. You're a smart operator. You know that you need to have fire insurance and liability insurance, and that insurance carrier will often send somebody by to inspect the place and tell you, hey, for fire compliance purposes, you need to not stack your newspapers right next to your water heater, and you're going to move those things. And you're going to make a number of other small changes that make it less likely that your facility is going to burn up in a fire. And if later there is a fire, well, you're insured for that. But some people choose not to get insurance. They choose not to make those small changes, and they find that when the building is burnt to the ground, that's the wrong time to be looking at, well, what do I need to do to change the conditions on site, and can I go buy insurance now? And the answer, of course, is no, you can't. Well, you can buy insurance, but not for the fire that's already happened. And that's the same with what happens in an ADA lawsuit. You've been served the lawsuit. Almost certainly the things that are listed in the lawsuit probably have some merit to them. And you need to make those changes and deal with this lawsuit. You can't say after the fact, well, gee, I would have made this change if somebody had just told me I could. Exactly the same as you can't say, I would have moved those newspapers away from the water heater if somebody had told me that that was a bad idea. I want to have my building back and not have it burnt to the ground. Those things, it doesn't work after the fact. So hire your CASP inspector now, make the changes that are outlined, help to insulate yourself from these kind of lawsuits by doing the right thing, being a member of the business community in good standing that has a business that's open and accessible to people of all types, including those with physical limitations.
Ken, thank you for that. Martin, I'd like to hand it over back to you.
Thank you. Thank you. Thank you, Ken. Thank you, Peter, and thank you to the Menlo Park Chamber of Commerce. It's an honor to be here. I'm located just up the road a little bit where I live and partially where I practice. I chair my firm's ADA compliance and defense practice. I have 4 attorneys who are working in our group, and we have handled over 800 ADA lawsuits over the last many years. I was thin and had hair when I first had my initial ADA lawsuit, and I've had 800 of them since. You might be interested to know that since the beginning of the year, there have been over 1,500 ADA lawsuits filed in the Northern District, where the cases involving your constituents were filed as well. And the vast majority of them, in fact, I think all of that 1,500 were filed by the Center for Disability Access, and perhaps no more than a half a dozen plaintiffs. Scott Johnson is probably the one who has been to the Menlo Park community. Brian Whitaker is another. I'm defending over 50 of these lawsuits right now. The ADA is what I do. It's what my group does. And we have been involved in cases involving Menlo Park business owners, as well as more than a dozen in Redwood City, restaurants that I represent in Redwood City and in Palo Alto. And so this is an area that we have a significant experience with. I've had over 300 cases with the Potter Handy or the Center for Disability Access group. Probably over 200 of them involve Scott Johnson. He seems to be the most prolific ADA filer in the country right now. Scott was indicted by a grand jury for tax evasion back last year, and is set to go to trial in April of next year. And just since he's been indicted, he's filed over 1,000 new ADA cases. He files at least 10 to 15 cases a day. So if you're a restaurant, if you're a hotel in Menlo Park, there are 2 kinds of businesses: those who have been sued and those who are about to be sued, if you haven't taken Roger Miller's advice and David's advice and brought your businesses into compliance. The things that Scott Johnson's a lawyer. I think he's no longer practicing. And he knows enough about the ADA to be able to roll down any street in America and find violations. They are so obvious. Yesterday, I was on Laurel in San Carlos. And even after the rash of lawsuits that have hit San Carlos, there were still parklets and outdoor seating areas that had inaccessible tables. And that's what they do. It takes literally 2 seconds to identify whether or not the tables are accessible. And it takes a few $100s to provide one accessible table. And then you avoid Roger, you avoid Ken, you avoid me, and you avoid being a defendant in a federal civil rights lawsuit. So let's talk about what happens when you're served with a federal civil rights lawsuit. You are a defendant. You have 21 days from the date you're served to file a responsive pleading, or I can assure you that the Center for Disability Access will take your default, either because the court requires them to take your default or because you haven't responded and they just go ahead and default you out. And then you have to deal with a default and hire me or Ken or another lawyer to get you out of a default, which can be an expensive proposition if they won't agree to remove the default. So the issues, I want you to know, take a deep breath once you get served. Don't see this as the end of your business. Yes, it's a hassle. It's going to take some of your time, and it's going to cost you money because you're not going to be able to settle the case. When if you were to call the Potter Handy Center for Disability Access firm and ask to speak to Amanda Seebach and ask her how much will it cost after you get done telling her why your business is not in violation of the ADA. And they listen to you and they tell you what it is, and we have pictures, and we have an investigator who has confirmed that it is. We want $26,000. I just got a letter like that for a nail salon in Redwood City. The plaintiff went from Southern California to Redwood City to get a mani-pedi. And I asked you, how far would you travel for a mani-pedi? A mile, a couple blocks from your house? You're not traveling 350 miles, 450 miles to get a mani-pedi. But that's what he did. He sued them. He sued the landlord. And as Ken was discussing, one thing that's really important to recognize, under the ADA, both landlords and tenants are what's called jointly and severally liable to the plaintiff, which means the plaintiff can sue either the landlord or the tenant or both. Now, as Ken mentioned, the ADA also recognizes the custom and practice in the commercial leasing industry is to have risk shifting provisions, such as the tenant being required to indemnify and defend the landlord. I have cases right now where just the landlord was sued, and we tender those cases to the tenant. But you got to be really careful if you're a landlord, because the tenant may not know what to do, may not know how to hire Roger or another CASP or a lawyer and be able to afford to defend the case, in which case you as the landlord can find yourself with indemnity rights that are not very valuable. So you have immediate decisions to make. First, before I would hire a CASP, if I were a restaurant or a hotel in Menlo Park or anywhere on the peninsula right now, I wouldn't do it without having my lawyer hire the CASP, because if you hire the CASP, the likelihood is that CASP report will be discoverable in litigation. And if Roger comes back and tells you that your bathroom needs to be totally torn out, you've got $60,000 worth of bathroom work, or you have a slope or a step leading into your restaurant, and it's going to cost you $25,000, $30,000 to redo the entryway, you may not have the money, or you may not want to do it. But if Roger was hired directly by you, then that report could be discoverable and used against you. Whereas if Ken or I or another lawyer hires the CASP reports to us, we then report to you, so that protects the findings that Ken might make. So you have to decide whether or not you're going to file an answer or you're going to fight the allegations. And as Ken mentioned, Scott Johnson is smart enough to understand what the issues are and to identify an ADA violation when he sees one. Now, he will only look at the outside. He'll just wheel by the restaurant, he'll look at the parklet, he'll look at the outdoor seating, and that's enough for him to get into court because he found a barrier that's related to his disability. And one thing for those of you who've been sued need to consider is a sneaky little paragraph, like it might be paragraph 23 to 25 or 26. It says that we believe that the violations are so obvious that you must have other violations within your space. And under a case called Doran versus 7-Eleven, the plaintiff is entitled to come back during the litigation with an expert and identify additional barriers related to their disability and bring those aspects of the case into it. So you might think all you have to do is change out a table with a 4-post table and you've solved the problem. Not quite. They can come back and they can go in, they can look at the rest of your restaurant. They can look at the seating inside the restaurant. They can look at your bar to see if it's compliant. They can look at the bathrooms. And so there are a number of things that can be basically expand the scope of the litigation. So watch out for that Doran versus 7-Eleven. So I think what you need is a global strategy, a strategy of how are we going to deal with these ADA lawsuits. I'm representing defendants, and I'm on the steering committee of the Chinatown ADA litigation. There have been nearly 100 cases there. And so we are considering asking the court to find that these cases are related, since they involve the same law firm, the same plaintiff, and then have them transferred to a single judge. Otherwise, what's going to happen is we're under what's called General Order 56 in the Northern District, which is a timeout in the litigation, and there will be site inspections with plaintiffs' counsel and their expert. I served on the advisory committee to the Northern District to revise General Order 56, and we recently did that. There will be the site inspection, but what will happen is the plaintiff will likely have the site inspection on different days. So that means the lawyer has to go back out each time they want to do a site inspection. So that becomes unwieldy. Then there are the court proceedings that if there are 10 or 20 different lawsuits, there are 10 or 20 different tracks, 10 or 20 different calendars. You want to try to consolidate those, in my opinion, and see if you can get a judge to agree to do that. And then the other thing we're doing is we're working with district attorneys' offices around the Bay Area, Alameda, San Francisco, Redwood City, and other. We're working with chambers, we're working with political groups, we're working with the representatives in state and federal legislations in order to try to bring around some policy procedures that will avoid situations like that. Now, that doesn't help anybody now. That's a more long-term approach. But in the intermediate time, I think you need to have your lawyer hire the CASP and to make sure the results are protected and either answer the complaint or fight it. We just filed 10 motions to dismiss in the Northern District for our Redwood City restaurants on the grounds that Mr. Whitaker and here Mr. Johnson are residents of distant jurisdictions, and the likelihood that they're going to be able to come up and go back to the same places when they've filed 1,500 lawsuits is unlikely. We got a judge in LA to dismiss the case. And so we were able to get the federal case dismissed, but having done that, then the plaintiff is entitled to seek damages in state court. So those are a few things. The tax deduction and tax credit that Roger mentioned are critical. They can make all the difference in the world. They can pay for any remediation you have to do. Insurance coverage, likelihood is there is none. There's no insurance coverage for ADA cases under a typical general liability policy. If you do have an employment practices liability policy, then there may be discrimination coverage, but the deductibles are usually anywhere from $50,000 to $100,000. So what does it take to settle these cases? It takes someone that the plaintiff respects and knows that we would work with our clients to make sure they do the remediation, and also that they can't kind of try to bulldoze over us because they know it won't work. These plaintiffs will likely open up, like I said, at $24,000 to $26,000, and they will drop fairly quickly into the mid-teens. And if you're lucky, you can get it settled for under 10, or you can litigate and fight it and see if you can win it. So those are a few of my comments, but the most important thing is don't panic. Don't just take a deep breath. We can figure this out. Lawyers like Ken and myself, we've been down this road so many times. We know the end. And so it's not pleasant. No one feels good when they're accused of discriminating against other people when they know they're not. But in effect, their businesses provide barriers that do discriminate against people with disabilities. Thank you for that.
Okay. Martin, thank you very much. Again, very, very informative, lots of details, and of course, lots of nuance. A number of questions have come in that I'd like to pose to various folks. Some are quick, some are not so quick, and I'm going to break them up in just a moment here. One of the questions that's come up has to do with what the city of Mountain View can do to help our folks. And John Lang from Economic Development from the city is on the call, and I'd like to throw it over to him.
Good morning. Pleasure to be here. So just to speak specifically about the city of Mountain View, as David mentioned, the city is a resource, and we are certainly able to come out and help give some guidance. And we are able to do that. And to a question that's in the Q&A, as far as an inspection for us to come out and look, there is no charge. We charge for the original permits, but to come out there and inspect and give some guidance, there is no cost to do that. So we are happy to do that. In terms of allowing encroachment into the street, very early on in this process, the city was doing a lot of walkthroughs and giving guidance as it relates to heaters and canopies, tables, with the health orders in effect that created that natural distancing between tables. A lot of the issues that come up in ADA lawsuits were not really present because of the health orders and the distancing of tables. But with the closure that went on in the winter and then the rapid reopening, there were a lot of things that happened where we didn't go back out as frequently as we had been out there initially when moving to the outdoors. And I think that is what's created some of the challenges, unfortunately. Both myself and Peter did walk Castro Street recently, and we did identify some issues where tables that should have been on the sidewalk are now down on the street, and that creates an instant issue with accessibility and access to that area. So we've done an informal walkthrough and started communicating with our business owners right away. David and myself are all available to do additional walkthroughs and help. And then the final thing I will share, this month, the city will be releasing its second round of small business grants. Earlier this year, the city offered business grants related to COVID. We had an oversubscription of the grants. Council approved additional funds. We will be opening up round 2 of grants, and I just got direction from the city manager that individuals that have been impacted by ADA lawsuits could apply for that grant. This is for Mountain View businesses. The only caveat I have to that is if we are oversubscribed to those grants, it will be a random draw. So there's not a guarantee, but that is something the grants can fund is ADA access issues or litigation. So that will be going out and being issued this month. Please stay tuned and we'll work with the chamber in communicating the launch of that program.
Thank you, John. Okay, so I promised some quick questions. So let me get through some of these very quickly. Could one of you describe the difference between being served and well, I'm sorry, I've misquoted the question here. Let me try again. I've lost it. I'm sorry. I'll go to it.
They've interrupted you.
Being filed, that's it.
Number of people have been receiving letters from 4 law firms. There's a law firm in San Jose, 2 in Sacramento, and 1 in the South. And what these lawyers do is they follow the ADA filings. And when these lawsuits are filed, they have a paralegal or someone, a secretary, find the addresses and names of the defendants. And they send out solicitations offering their services. The letter starts out, you may not know this, but by the time you get this letter, you may be served with a summons and complaint. You've been sued in federal court. We're the best. We do this all the time. Please hire us and we'll defend this case and make it go away. One fellow offers of $1,000 to defend the case, but what he means by that is he immediately calls plaintiff's counsel and he settles it for $12,000 or $14,000 or whatever the plaintiff demands. So that is not service. And when I did my Chinatown presentation to the business owners, many of them received those letters and were truly confused. It's only when a process server comes and serves you personally or by substitute service that you've been served. And until you're served by a process server, you're not a defendant in a lawsuit.
Thank you.
And Peter, I'm going to follow up on one point that Martin brought up earlier in his discussion, and that was this idea of you can choose to settle a case or you can choose to fight a case. I know I'm misquoting him, but the idea that I have is that often these cases present such an obvious violation of the ADA, you're going to lose the case. So the question for you is how badly are you going to lose the case? And the more you fight, one of the components that people don't recognize is that there is an attorney fees component built into the statutes. So the plaintiff's counsel that file these lawsuits that they know they're going to win, they want you to fight them. They want you to engage in protracted litigation so that instead of settling the case for under $10,000, as Martin mentioned, these cases become $50,000, $60,000, or $100,000 cases. The same violations exist, but now they have a justification for presenting to the court a motion for attorney's fees after defeating you that is quite substantial, because they're going to say, hey, look, they had the opportunity to resolve this case early on in a very clear liability case. So what does settlement usually involve? It usually involves identifying with somebody like Roger, with their help, identifying all of the existing ADA limitations and ensuring that those get fixed. And then you contact the plaintiff's counsel and you say, we are taking care of the one that you've identified. You said that the slope on the wheelchair ramp was too steep and I couldn't use the wheelchair ramp. So it has to be redesigned and it has to be fixed. And usually there's a period of time in which you can get that done. And then there's a financial component as well. And that can, depending upon how much the plaintiff's counsel will be able to justify that they've spent already in attorney's fees, you may settle this for something under $10,000, or it may be 15, 20 or more. If your initial reaction to a lawsuit is to kick and scream and fight and put up a lot of trouble for them, it's going to cost you more to settle the case. There are appropriate times when fighting lawsuits makes sense, and hiring a good attorney that understands when to do that and when not to do that is important. Hiring a competent counsel who's been there before and recognizes this is a dog, you're going to lose this, you were in violation of the ADA, versus there are legitimate defenses that we can raise that we believe we can win on. And you make that decision early on in litigation. You can't go fight a losing case extensively and then expect to settle it for the same amount of money. So you'll spend money on your own attorney, you'll spend a lot of money on the opposing party, and you're still going to do the compliance. But if you have to make, so you make that decision with the advice of counsel very early on. Am I going to fight this case, or am I going to settle this case? But it's inadvisable, in my opinion, to say this case is a loser, but we're going to fight it anyway because we want to make a point, and then settle the case a year later. That just doesn't make sense.
Yeah, I agree with that. You have to be very judicious about which cases you fight and which cases you decide to settle, and you keep your powder dry for the ones you're going to fight. And when it comes time to settle, I only settle for what is alleged in the complaint. I never agree to settle for other things that the plaintiff hasn't brought up yet. I will recommend strongly to my client, having done a CASP assessment, that they fix the other things, because settling with one plaintiff, and this is really important, settling with one plaintiff does not protect you from the next plaintiff who comes in to your restaurant or your bar or your facility. It's you don't get any protection other than that one person.
I agree with Martin on all of that. I do the same. I would not notify the plaintiff, in addition to the wheelchair ramp, we've also changed the bathroom, and we're going to be working on other things to make, the tables more accessible, et cetera. But nevertheless, a business owner does need to do those things, or they are going to be facing liability from somebody else, almost certainly.
Gentlemen, there's some questions that are related to some of the things that you just said, and I want to make sure that we clarify these for the listeners. And that is that, first of all, with regards to some of the requirements of the ADA, for example, table height, which says 30 inches. If they're 29 3/4 inches, is there any leeway, or is it truly the letter of the law? I mean, that's the first question.
A great question for Roger to answer, I think, but there is some leeway. It's unusual circumstances. If it's new construction, there's really no leeway. You build the counter to 34 inches on the spot. No, I know there are some that say minimum or maximum heights. Then you do get some flexibility, but ordinarily, when it says 29.5 inches, that's 29.5 inches.
There is no excuse for a contractor being unable to use a ruler. There is no excuse for an architect being unable to draw a plan that adequately complies with the ADA. Therefore, as a lawyer, I cannot offer any excuse why you built it wrong.
That's right.
And I've got some input on that. The fact of the matter is, almost all the dimensions in the ADA and the California Building Code have a range. Minimum of 29 inches, maximum of 34 inches for a countertop. You've got plenty of construction tolerance. You've got from 15 inches above the finished floor to 34 inches. The fact that you built it at 34 1/4, as has been stated, is somebody can't use a ruler. They should have built it at 29 3/4.
Yeah.
When I review plans, I encourage architects to not try to use the maximum dimension. Don't use 8.3% on a ramp. Ask for 7% or 7.5%. That way the contractor has some margin that he can build into it, because the truth of the matter is, it says a maximum of 8.3%. And I just was involved in a situation where the guy had a 4-foot level and he said, I'm have an average of 8.3%, but I took my 2-foot level, which is designated by the DOJ as the right level. And he had 8.4% in some locations and 9% in some locations. He had to redo the ramp.
Yeah.
So you have tolerance built into the code in almost every instance, and there's a whole book written on construction tolerances that you can use if you get into litigation you're trying to settle, but you're not gonna have much success with that, I don't think.
And the expense to litigate over a tolerance, unless it's really important, is going to be far more expensive than it's worth, I think.
Yeah, Starbucks litigated over a nuance on their counters, but that involves hundreds and hundreds of counters.
That's right.
And they actually were successful in litigating over the clear space on a counter. But I don't know that you can use that as a precedent on every case.
Now, Starbucks also spent probably $1 million or more in litigation fees to get to that point, and expert fees. Most businesses can't come close to affording that.
Well, and it was a good business decision for Starbucks to do so, and they had a large and well seasoned litigation team to advise them on when it was appropriate to make that choice, and that's just out of the reach for most the small restaurants.
I represent Bed Bath & Beyond, and they had a feature in their bathrooms that the plaintiff claimed was wrong and violation of the ADA. And they had that feature in about 175 stores around the country that were built on the same design. And it would have cost about $30,000 for each store to do the renovation. So we fought that and we won at the Ninth Circuit as well.
I think that this question is actually more towards either John or David. And that is that what type of protection does a tenant have from a landlord making fixes and then passing those charges down to the tenants?
Actually, if you don't mind me redirecting that to my table, that's actually the exact work that I do.
Okay, great. Thank you, Ken.
So I represent landlords, I represent tenants in commercial leasing. And this question comes up all the time. Tenants frequently say that the landlord made some very expensive change to comply with the ADA, and they're passing that on to all of the existing tenants. And what can I do about that? And the answer is, it's written in your lease. Almost certainly the answer is in your lease. Some landlords will set up a lease so that they say we are on an annual basis or on a monthly basis. We're going to collect money from you in reserve to be used at some time when we get around to doing the thing that's required. You know, the roof, the restriping, the parking lot maintenance, etc. And other landlords will say, when these expenses come up, I will do them and I will pass them along to whatever tenant currently is in existence in my business. And that is just a matter of leasing law. What does your lease say? If you have a triple net lease, the landlord is entitled to pass along certain expenses. Typically, those triple net leases are written in a way that you pass along expenses that exceed a fixed number, a base year that they use to say our maintenance is typically, $100,000, and we're going to divide that amongst our 6 tenants, and they each share in that. But we're going to be charging you for a percentage of that or none of that, but we're going to charge you for everything that exceeds that. That's a base year computation. And often these ADA fixes are necessary. They're urgent. They are expensive. So the question is, does a landlord absorb that? Does a tenant absorb that? Look to your lease. Almost always the landlord will either immediately or over time pass along that expense to the tenants.
Okay, thank you on that. One of the things that, one of the other questions that's come up is, is there any liability insurance or any kind of insurance that covers these kind of lawsuits?
The answer to that is no, not general liability insurance. Up to about 10 years ago, insurers were defending ADA cases and they were paying to settle them. And then a clever coverage lawyer filed a claim and was able to convince an appellate court in a case called Navigators Insurance that there's no occurrence for an ADA violation. The table is there. I didn't fall off the table or under the table. The table's there, the step is there, the curb ramp is there, the slope is there. It's not an occurrence. It was intentionally designed. So again, under general liability insurance, no. Under EPLI, employment practices liability insurance, probably.
Some of our businesses, of course, have gone out of business during the pandemic or whatever, and we're still served.
Yes.
Are they liable?
For damages, yes. Not for injunctive relief, because for injunctive relief, the court would have to find that there is a likelihood that in the future, what the plaintiff will go back to that location and then encounter the same barriers. If, however, the business is closed, then the federal court will throw the case out. But then the plaintiff could refile in state court for damages under the Unruh Act. The ADA does not provide for damages to private plaintiffs. It only provides for injunctive relief to require the business to comply with the law and attorney's fees. However, to get damages and to incentivize the plaintiffs to actually get on board and be out in front of these lawsuits, they get paid $4,000 to $8,000 for every one of these cases. And so that damage claim could still exist because the plaintiff encountered the barrier while the business was open and therefore sued the business for damages. But if the business is out of business, then there's nothing for the plaintiff to litigate over.
Yeah, the only way that they get directly to those individuals, there may be individual liability if the business owner wasn't protected by a limited liability company protection or incorporation protection. If they were just operating the business as a I'm going to use the term mom and pop, right? They didn't send up some kind of separate entity. They may be personally liable, but oftentimes these just go away because the business is gone.
Yeah, and the plaintiff in this case is not going to invest their seed corn going after a business that's closed just to get $4,000 or $8,000, although they can get their attorney's fees from the federal court case too.
Roger, I have a quick question for you, and that is that if a restaurant or a business has a parklet, do they need a ramp or is street access sufficient?
They need an accessible route throughout the property. So if you've got a bathroom inside, they need an accessible route from the bathroom into the parklet. They need an accessible route to get somebody into the parklet. So if there's an existing curb ramp, that may serve as an accessible route, assuming the curb ramp is compliant and your route of travel is accessible.
Is there a limit to, when you say accessible, obviously if you're in the middle of the block, that's quite a distance rather than if you're on the corner. And so is there a distance requirement as well?
There's nothing measurable in the code, but what it says is you have to give equal accommodation. So I can't make somebody that's disabled run 100 feet down the block, come down a ramp and 100 feet back when I allow somebody that's not disabled to just step off the curb.
I think every parklet has to be accessible from the curb, the public sidewalk. And most of the parklets that I've seen have built up a platform level with the sidewalk, and that's okay. But those who have not and have the parklet on the asphalt of the street and no way for someone in a wheelchair to get there, they're in serious trouble. They will get sued.
Yeah.
And it's serious and obvious trouble. That's the kind of those are the drive-by lawsuits where somebody doesn't even have to get out of the car and say, well, that's a place that we're going to sue, and I'm just going to allege that I attempted to get served and was unable to be served, and they'll win.
Yeah.
There was one location that I observed, did an inspection on, not because of the parklet, because of the general inspection, and they had a curb ramp that was right at the parklet, which worked okay.
Yeah, they're lucky.
Yeah, but it was an existing curb ramp, and the curb ramp happened to be compliant, which is often not the case.
Now, if the parklet is going to evaporate anytime soon and be removed, or service removed from the public street, then that's a case you can win. That's a case that, again, remember, the general rule is federal courts have limited jurisdiction only to enjoin people from violating someone's future civil rights. And if they're no longer going to be a parklet there, then you have a really good defense in an ADA case, because the federal judges do not particularly like these serial ADA plaintiffs and these serial ADA filings. Give them a good voter registration civil rights case, or access to a courthouse or to a library. That's one thing, but a table that has a rounder instead of 4 posts, then I couldn't eat there. If they wanted to eat there, these plaintiffs could eat there, but they also have an obvious low-hanging fruit lawsuit.
A related question is that if the accessible ramp at the corner or the sidewalk or anything else that's street oriented, if you will, is that the responsibility of the city or the responsibility of the owner, or is that the responsibility of the lessee?
I think, look, the tenant, John, and John, I guess you guys can answer this, but the tenant has no ability to alter a public sidewalk or to alter a ramp. In Chinatown, we're dealing with situations where there's a level landing and then it slopes right down the sidewalk with the rest of the block. And you can't fix that as a tenant. You can't encroach in David.
David, do you want to add to that?
Yeah, I would agree. I think everything we're talking about in terms of the parklet is public right of way, and it's part of the overall city public works improvement plans that they have, and they systematically go around and improve this as they can. But there are, like Martin's saying, there are some physical characteristics of sites that just make it difficult to modify to be fully accessible.
Well, the
David,
public right of way has a different set of regulations.
I'm sorry, I couldn't quite.
How long will the parklets be allowed to remain?
In Mountain View, they'll be allowed through January 3rd.
In my opinion, that is a short enough time between now and January 3rd that it's improbable that a federal judge is going to entertain that lawsuit. They could still sue for violations of the California laws, for the accessibility laws, and California provides for a per incident fixed dollars per incident that you can sue to recover. And so the question is going to be, is there really any meat on that if you can't look for how am I going to also justify the attorney's fees to chase somebody over $4,000 or $8,000? I just don't see those lawsuits as having a lot of merit on a long-term basis.
Yeah, I don't either. And if I were defending a Menlo Park business that had a parklet, I would make that the first sentence in my response, Judge. This case will disappear on January the 4th, when the parklets are no longer prohibited. Permitted to be on in the sidewalks and the streets, because again, you will no longer have a risk of injury because the parklets will be gone.
Right.
Nobody will be going out into this.
Don, it looked like, excuse me, Roger, it looked like you were going to add something to this.
Well, I wanted to point out a distinction. The California Building Code and the Public Rights of Way are two different sets of regulations.
Yeah.
Public Rights of Way has a different set of guidelines on what you need to do as far as accessible routes, and takes into account that you can't build everything level. When you put these parklets in the Public Rights of Way, you should be making them not down on the parking spaces such as elevated, as I think somebody else said. They should be elevated to the curbside, so you're not depending on a curb ramp. It's just a matter of building a raised wood floor that then provides an accessible route. So that avoids the obvious lawsuit that I couldn't get there.
Once the danger of an injury is gone, federal courts have an ongoing obligation to continue to monitor their cases. And once that parklet is no longer permitted, there's no longer a danger of injury because they won't be able to encounter a barrier there. The judge will then have to throw the case out. And so maybe the better approach is to simply just not to fight these cases until at the beginning, but to put an answer on file and then let it wait for the next 6 months or 4 months, and then make a motion for summary judgment on the grounds the parklets are gone, and you can wipe out all of these cases from federal court. And then if they want to go in front of a Menlo Park judge, a Superior Court judge, and try to convince them that they should get a lot of money because the table was a little too high or short or whatever it might be, let them try that. That's what we're doing in Redwood City.
I agree with that. Yeah.
And I would add, in terms of what was done during the pandemic, a lot of these outdoor parklets were from a building department and as well as public works were really considered kind of the equivalent of temporary use sort of pandemic condition. So they all are going to go away more often than not.
Yes. One thing, a lot of people have these tables with these inverted T legs. And so there's a pole on each side, and then it has a base, and the base has a bulge where the table leg fits into the base. And so somebody will take a tape measure and say, I measured my table and it's 30 inches because I measured between the legs, from leg to leg. But what they didn't do is they didn't measure from the inside of the bulge on each side. And now they're no longer 30 inches wide, they're 28 inches wide. A violation. Would you agree, Roger?
Yes, I agree. The solution is a four-legged table.
Yes.
And it's not expensive to do. It's the simple, straightforward solution. A four-legged table that has 27 inches underneath it and no more than 34 inches to the top, and you've got an accessible table.
Yep. If you do have one of those legs, tables with those two legs, spread them out, see if you can get 30 inches between the bulges. And then I've got tables and resources of all kinds for ADA compliance. I'm sure you do, Roger and Ken. And so these are available. Cost you $400 or $500, you get an accessible table. A lot cheaper than dealing with any of us.
On that note, we do have many more questions as we had assumed we would, and I'm afraid we won't be able to get to them in the time allotted. But we will forward these on and see if we can get them and some of these answered offline. With your permission, I would like to put your contact information into the Q&A box so that people can follow up with you directly.
Yes, of course.
Any problems with that, let me know. So we will drop that in. And also a number of questions have come up from people saying, will this be available? Will this recording be available? The answer is yes. We will make it available. We will put it up on YouTube shortly, and we will send an email to everyone who registered as to how they can access it. So we hope that that will be the case as well. I want to thank everyone for both our presenters as well as our viewers. And I also want to just make a mention that some of the comments that we received were from disabled people. And I want to just make the statement that I think we all take these challenges seriously, both from the perspective of access as well as the perspective of providing that access. I believe that all the businesses I've spoken to want to welcome everyone into their store or their restaurant or whatever. And I believe that every patron has a right to be able to take advantage of those services. So I want to thank everyone here to have that in mind. I want to thank everyone for their activities to make sure that we can have a more equitable environment. And with that, let me just put the information in the chat. I'll also send it out to all the residents. I think that'll be all recipients. That'll be easiest. And thank you all for your participation today.
Very welcome. Thank you for the opportunity to speak with your group.
It was really a pleasure being here. Thank you very much for the floor. I appreciate it.
Same here. Pleasure to be able to communicate, and thanks for the opportunity.
Absolutely. Thank you.